expert who can give the insights, which normally looks to be very basic. That is the plain particulars and procedures in the CPC. In this regard, we had requested Mr. L.S. Satyamurthy, and who acceded to our kind request to give the insights to this topic. Those who have been following him would find that a lot of his videos on different perspectives of law are already viral because people feel that the way he explains the things are in a subtle and in an erudite manner. He is presently a district judge in the special court for CBI. And CBI, as we all know, has carried its own space within last years. And without naming the famous judgment wherein we spoke about how it is acting upon, etc., etc., I'll just say that he's also an author of a book known as Purya Nokil Protect Kavignar, which I would be very candid that I will ask him to explain the meaning. I cannot say that I've understood the entire meaning for that. And he has famous judgments which have been accepted up to the Supreme Court. Without taking much time, I will request Mr. L.S. Satyamurthy to give the insights on topic which people would love on a Sunday to hear from him. Not only on the participants who are watching us on this platform, but also those who are watching us live on the Facebook. Over to you, sir, and thank you for accepting our invite.
Thank you, Mr. Vikas Chandra, for providing me this opportunity to interact with the legal fraternity, who are the distinguished jurists length and breadth of this country. I am also happy to discuss on the topic that you have assigned to me is the pliant, the particulars and procedures under the Code of Civil Procedure. Members of the legal fraternity of the great nation, my dear young lawyers, good evening to all of you. I'm really happy that at least 55 of our members have sacrificed their pleasant Sunday evening and joined in this webinar as delegates to discuss on the pliant. As I told, as Mr. Vikas has spoke earlier, this is the program sponsored by Beyond Law, but we are going to discuss everything within law. Though it is sponsored by Beyond Law, we are going to discuss everything within law. So now, sir, the topic today is, so screen share, sir, screen share, please. So please enable me to screen share. Please screen share, sir.
Allowed.
Yes, sir. Oh, thank you, sir. Now that, sir, is it visible, sir? Playing screen not visible, huh? Sir, please enable me to allow me to share the screen.
It has already been allowed earlier also you tried it.
Oh. No.
Yeah.
What about now, sir?
Yeah.
Sir, why the topic is very important? Pliant, its particulars and procedure under the Code of Civil Procedure. I would narrate it as a story, sir. So today it is a Sunday, a pleasant evening. A lawyer is attending his chambers work. and a client is knocking at his door and requesting him that, sir, he is narrating an event. Sir, I have been a tenant for a premises. It was leased out to me by a landlord who is elsewhere in United States. I have been running a shop there for the past 1.5 decades. And I have been paying the rent, and there is absolutely no default in payment of rent. Despite of all those things, a few persons came a couple of days before. 2 persons came and claimed some novel rights, and they asked me to vacate the premises within a week. If I do not oblige them, they have threatened that they would dispose me from the premises of the property. So what to do, sir? A client has approached the lawyer, and he is knocking and he is narrating the things what happened to him. Immediately, a lawyer is now start the process of drafting a plaint on the instructions from his client. He has drafted the plaint. The plaintiff is a tenant. There is an agreement, a lease agreement or tenancy agreement between himself and the landlord. And it has been in existence. The landlord and tenant relationship is existence between the plaintiff and his landlord. And the plaintiff is also paying the rent to the landlord regularly without any default. Whereas some persons are attempting to dispossess him from the premises in which he is entitled certain statutory protection. When he is entitled to the statutory protections, how these persons can take the law into their own hands and dispossess him from the suit premises. These aspects has to be drafted as a plaint. The narratives of the client, who is a layman, has to be drafted, and the documents in support of the drafting has to be annexed with the plaint. Lease agreement, tenancy agreement, the receipts for payment of rent, other documents to show that the plaintiff is running a shop there. After drafting everything, an advocate has to state how the court has got jurisdiction to try the suit and what are all the protections, legal protections available to the plaintiff, and how the suit is within the period of limitation, and the valuation of the suit. After all these process, the layman has sought for some sort of legal protection to his tenancy. That has to be that relief he has sought in a layman language. What he has sought for in a layman language has to be given a legal color, and he has to draft the plaint. Therefore, plaints are drafted in the chambers to sustain in the court of law. The plaints are drafted by the lawyers to present it before the court to seek some sort of relief. Now that after collecting all the instructions from the client, the lawyer has drafted a plaint and sought a relief before the court of law that the plaintiff should not be dispossessed from the suit premises except according to the procedures established by law. This relief sought by the plaintiff is molded, shaped, and fine-tuned by the lawyer by his ability, by his drafting competency. After that, he is presenting the plaint into court, and he is convincing the court and getting an order in favor of his client. Therefore, plaint is a first and foremost product of a lawyer. It reflects the competency of the lawyer. It projects the drafting skill of a lawyer. Therefore, I would say that the plaint awareness, a plaintiff who signs in the plaint and who verified it as per Order 6, Rule 14 and 15 may be a de jure author of the plaint, but the advocate who drafted is a de facto author of the plaint. Therefore, along with the plaintiff, the advocate who is presenting the plaint is also is also subscribed his signature in the plaint. It reflects the legal acumen of a lawyer. It is the way in which he is convincing the court by narrating the events that he has collected through from the instructions of his client and presenting it before the court of law. As I told you earlier, plaints are drafted in the chambers of the lawyer, but are presented to the court of law, and the results of the plaints are drafted in the form of decree at the chambers of the lawyers, chambers of the judges. Therefore, plaint is an extremely important document. A plaintiff may be a de jure author, but we can consider the counsel who is drafting and presenting it into the court of law is a de facto author. Now, sir, why a plaint is so important? Unless a proceeding starts with a plaint, an order in such a proceeding does not result in a decree. Therefore, without presenting a plaint, no court can pass a decree. To avail a relief in the form of decree, plaint is an important document presented into the court. It is the averments in the plaints that decides the jurisdiction of the court. In a way, again, I am emphasizing it. It is the lawyer who, by his drafting ability and his skill, convincing skill, making the court and convincing the court that the court has got jurisdiction to entertain the plaint. And the third and most important one is that any amount of evidence adduced by the plaintiff beyond the plaint averments will be of no use. Therefore, at the time of trial, the plaintiff can adduce evidence only touching the pleas raised by him in the plaint. If any evidence adduced or let in by the plaintiff beyond the plaint averments will not be looked into by the court of law at the time of trial. Therefore, a plaint is extremely important document for the reason that only the plaint is a document to get a decree from the court of law, and it is the only document which convenes the court to decide the jurisdiction of the court, and any amount of evidence adduced beyond the scope of the pleadings or beyond the plaint averments will not be looked into by the court. Therefore, the plaint is a very important document. And now, what is plaint? It is not defined in the Code of Civil Procedure. I am very often emphasizing that the Code of Civil Procedure 1908 is the oldest surviving adjective law applicable to the courts of civil judicature in India. And there is no definition for the term plaint in CPC. There has been almost 21 definitions given in section 2 of the Code of Civil Procedure. Of course, there is no definition provided for the word plaint in CPC. But there are certain things we can infer from the practice and law of pleadings and other procedures that we are adopting while filing a plaint, that one first and foremost thing is that a plaint is a statement of a claim. It is a document. By the institution of a suit, I mean the presentation of plaint, is the institution of the suit. Though institution of suit, the commencement of the institution of the suit commence from the presentation of the plaint. Above all, a plaint is the pleading of the plaintiff. It consists of the grounds upon which the assistance of the court sought by the plaintiff. By presenting the plaint, a plaintiff is seeking the assistance of the court that I have a case in my favor, that I have a civil right in my favor. Let the court protect my right. Let the court give me some relief to protect my interest. Therefore, it consists of the grounds upon which the assistance of the court is sought by the plaintiff. And then, as per Order 6, Rule 1, pleading shall mean plaint and written statement. The plaint and written statement both consist of the pleadings. Both the plaint and written statement. Plaint is from the part of the plaintiff, and the written statement is the written statement of a defendant. Both are the part and parcel of the pleadings. The object of the pleading is to enable the court to decide the true rights of the party of the trial. So what is the purpose of pleading? A law of pleading says that the object of pleading is to enable the court to decide the true rights of the parties in the trial. This is the law laid down by the Supreme Court of India in state of Maharashtra versus Hindustan Construction Limited, 2010, 4 SCC, page 418. And there is a definition, the earliest definition for the plaint are available in two of the decisions. One is from the Madras High Court, other one is the S2L Mysore High Court. Asan versus Patuma, ILR 1899, it is the plaint. The CPC came into effect from the year 1908. Even before the commencement of the CPC, there was a definition for the word plaint that was given by the Madras High Court in 1899, 22 Madras, page 494. And after the commencement of CPC in the year 1969, the Mysore High Court, the S2L Mysore High Court, as in Girijabai versus Thakur Das, AIR 1969, Mysore, page 217, has defined the plaint in its own words that the plaint is a private memorial. It is a private memorial tendered to a court in which the person sets forth his cause of action, the exhibition of an action in right. A private memorial tendered to a court in which the person sets forth his cause of action, the exhibition of an action in writing. This is the earliest definition available for the plaint by the High Courts of Madras and Mysore. And now that, sir, I have stayed from the very inception of this webinar lecture. I have stated that along with the plaintiff, the counsel appearing for the plaintiff also subscribing his signature in the plaint. If it is so, an interesting question has came up before the Madras High Court. After the suit, commencement of the suit, there has been memos and petitions and other documents and other types of presentations were there on the part of the plaintiff and defendants. In a suit, when the proceedings were in progress, a memo was pressed into service by a counsel on record. The other side has insisted that the party should also sign it. The Madras High Court in Mangairkarasi versus Susila, the decision reported in AIR 2000 Madras, page 266, has held that the moment plaintiff gave a wakalatnama to the advocate, to his counsel on record, his counsel can present any memos, and it is not mandatory, and it is not a requirement that every memo or every paper presented into the court on behalf of the plaintiff shall carry the signature of the plaintiff. Therefore, a lawyer has been empowered to present papers, documents, memorandums to incidental to the plaintiff during the course of the proceedings on behalf of the party, on behalf of the plaintiff, and it need not require that every paper presented into the court shall consist of the signature of the party. And then, sir, we are talking about the forms of pleadings. We are well aware that a plaint has to consist of the name of the court, cause title, everything. The framers of the CPC have suggested 49 models. There are 49 pro formas prescribed for plaints in Appendix A of the Code of Civil Procedure. All the 49 pro formas are the standard forms of pleadings, as nearly as may be used for all pleadings. But what is very important is that the forms could be read along with Order 6, Rule 3 of the Code of Civil Procedure. What is Order 3, Rule 3 of the Code of Civil Procedure? Order 6, Rule 3 deals with the forms of pleadings. The forms in Appendix A, when applicable, and where they are not applicable, forms of like character as nearly as may be shall be used for all pleadings. Therefore, the Appendix A, the 49 types of 49 models of plaints given in Appendix A has to be read along with Order 6, Rule 3 of the Code of Civil Procedure. And then, what is the commencing point of a suit? This is in Order 4, Rule 1. Every suit has to be commenced by presentation of a plaint. So plaint is the commencing point of the beginning point of the institution of suit. Every suit shall be instituted by presenting a plaint in duplicate to the court or such officer as it appoints in this behalf. Therefore, it is extremely important point that the presentation of plaint, because the commencement of the suit commencement of the suit is only from the point of presentation of the plaint. And then every plaint shall comply with the rules contained in Order 6 and 7 so far as applicable. Order 6 pleadings and Order 7 plaint. These two orders and rules, the rules there in Order 6 and 7, they are all applicable for every plaint because the plaints are governed by Order 4, Order 6, Order 7. The plaint shall not be deemed to be duly instituted unless it complies with the requirement of the subrules 1 and 2 of Order 4. There are certain mandatory requirements to be fulfilled at the time of presentation of plaint. If the plaintiff has not complied with these requirements in subrules 1 and 2, it cannot be deemed that the suit was instituted. I mean, the suit was instituted by a presentation of plaint. And now that's why the plaint is important. These aspects we have discussed. And the second part of this lecture is what are all the particulars to be contained in the plaint? Under Order 7, Rule 1, the first and important aspect, important requirement is on the head of the plaint, the name of the court in which the suit is brought. The name of the court in which the suit is brought should be at the top of the plaint. And then the name, description, and place of residence of the plaintiff, and the name, description, and place of residence of the defendant, so far as they can be ascertained. See, we can, in a legal parlance, we can call them both short cause title and long cause title. In a plaint, after the name of the court where it is to be instituted, there shall be the names of the plaintiff, and the name of the defendants. Thereafter, the description, name, father name, age, and other identifying descriptors, the address of the plaintiff, place of residence, place of business, everything. These two things are short cause title and long cause title. Why the framers have said that the description and place of residence of the defendant, as far as they can be ascertained, sometimes the plaintiff cannot ascertain the address or other particulars of the defendant. In such circumstances, the framers have given the liberty to the plaintiff as far as they can be ascertained. So the short cause title and long cause title. After that, the plaintiff or the defendant is a minor or a person of unsound mind, a statement to that effect. That is the very important one. See, the framers of the code have enabled the physically and mentally challenged person also to institute a suit through a next friend or through a guardian appointed by the court, or through a guardian, de facto guardian or natural guardian. So even a mentally challenged person can also be a plaintiff or defendant and approach the court of law. But what is very requirement of the plaintiff is that there must be a statement to the effect that the plaintiff is a minor, or the plaintiff is unsound mind. He has been under the care and custody of so and so. These particulars has to be pleaded, and it is the mandatory requirement of the plaintiff if it is a plaint, and it is a defendant is a minor or defendant is a person of unsound mind, then that has to be detailed in the plaint awareness. And then very important, where the lawyer has to utilize his legal acumen to show that the facts constituting the cause of action and when it arose, how the plaintiff, how the suit has got a cause of action. Without a cause of action, a plaint is a dead body without a soul. Cause of action is the soul of the plaint. So without a cause of action, no party can approach the court of law, and no plaint is sustainable before a court of law. Therefore, the facts constituting the cause of action and when it arose, these are the material facts to be necessarily pleaded in the plaint. It is the work of a lawyer, and lawyer has to make it to the court that there is a cause of action for the suit and it arose on particular date. Then how the court has got jurisdiction. It is also a part of the lawyer. The lawyer has to convince the court the case of the plaintiff narrated in the plaint and the relief sought by the plaintiff are well within the territorial jurisdiction of the court, pecuniary jurisdiction of the court, and the court has got competency, power, and jurisdiction to entertain the plaint and also grant the relief. Here also again the lawyer has to articulate, the lawyer has to draft the plaint in such a manner to convince the court that the court has got a jurisdiction, both entertain the suit and also to grant some relief in favor of his client. In that way, the plaint is very, very important. At the last stage of the plaint, the relief sought by the plaintiff, the relief of specific relief of partition and separate possession, recovery of money, what sort of relief the plaintiff claims has to be specifically stated for the purpose of granting the relief in favor of the plaintiff. Therefore, the relief which the plaintiff claims is also to be there in the plaint. These are all the works of the great lawyer who has to draft those things in his chamber, because the plaint drafted by him will be encountered with a written statement by a competent and able lawyer at the time of trial. Therefore, a lawyer has to take pain. A lawyer has to make it a case in favor of his client in the plaint. And then, sir, where the plaintiff has allowed a set-off or relinquished a portion of his claim, the amount so allowed or relinquished has to be pleaded. The next important aspect is there might be a relinquishment of a certain portion of claim by the plaintiff, or the plaintiff may allow some sort of set-off which would be the claim of the defendant in the money suit. That has to be specifically pleaded. After that, a statement of the value of the subject and the purpose of jurisdiction of court fee as far as the case admits. It is again a job of a lawyer that the subject matter of the suit has to be properly valued, and for the purpose of court fee, the valuation of the subject matter has to be given in the plaint, and to that proportionate rate court fee has to be paid, and again the lawyer has to convince the court the value of the subject matter of the court is well within the pecuniary jurisdiction of the court. These are all the very important matters to be drafted by a lawyer, competent lawyer, as required under Order 7 Rule 1 of the CPC at the time of framing a plaint. If plaint drafting is more or less a case, making a frame of a case. So a lawyer is framing a case of his client by complying with Order 7 Rule 1. Again, it is reflecting the lawyer's right, lawyer's ability of conveying, drafting, conveyancing, a lawyer's skill in convincing the court in the art of framing a case in favor of his client. So, how to draft a plaint under Order 6 and Rule 1 and 2? So this is mere formal procedures. The plaint averment shall, wherever necessary, be divided into paragraphs numbered consecutively. A plaint has to be drafted not without any full stop or comma. It has to be drafted in paragraphs. The plaint averments to be divided into paragraphs, and the paragraphs have to be numbered consecutively. And each allegation has to be averred in a separate paragraph. Art of drafting a plaint is there embedded in Order 6 and Rule 1 and 2. Each allegation has to be averred in a separate paragraph. Thereafter, what is very important is that the date, the amount, sum of amount, and other numbers involved in the property. For example, the taluk, the survey numbers, the door numbers, and other numbers all those dates, sums, and numbers shall be expressed in the plaint, both in figures and words. These three mantras for drafting the plaint as per Order 6, Rule 1 and 2 is the plaint averments need not be a lengthy paragraph, need not be without any comma or full stop. It need not be narrated into pages. It has to be divided into paragraphs, and the paragraphs have to be numbered consecutively. Thereafter, every allegation has to be, as far as practicable, covered in a separate paragraph. The most important thing is, whenever there is a numbers, it should be, whenever there is a figures, it should be expressed both in words as well as figures. Then, what are the contents of the plaint? This is the elementary principle of law of pleading, that the material facts alone can be pleaded and not the evidence. This is what Order 6 to 2 again I am quoting. It is only the material facts and not the evidence. The plaint shall contain a statement in concise form of material facts, and evidence need not be pleaded. The material facts alone to be pleaded. And then in the plaint, if the plaintiff relies on misrepresentation, fraud, breach of trust, willful default, or undue influence. If in case of it is a claiming of rent, if there is a misrepresentation by the defendants or any person, or if the suit is based on a misrepresentation, allegation of misrepresentation, or if the plaint is the basic, the plaint is on the foot of a fraud committed by some other persons, and the wrongful loss caused to the plaintiff, if any, or if the plaint is for the breach of trust, those matters has to be very, very specifically pleaded. And then if it is a willful default or undue influence, everything, in addition to the specific pleading, the date and what are all the items and what are all the actual, what transpired and what was the loss, everything has to be specifically stated in the plaint. When the plaint is not defective, there are Order 7, Rule 1 and 2, Order 6, Rule 1 and 2. These aspects have to be pleaded, and these aspects have to be specifically pleaded. There are certain mandatory requirements to make it. There are certain ingredients to be fulfilled for a comprehensive plaint. But when the plaintiff is not, if the plaintiff is not aware of the particulars of the defendant, an insufficient or improper description of the defendant does not make the plaint defective. That is what in Order 7, Rule 1 and 2, while I was talking about the short and long cause title, I have emphasized that sometimes the plaintiff may not aware of the actual address of the place of residence, of the place of business of the defendant. Even he may not aware of the father's names or from where he is hailed, everything. In such cases, if there is any insufficient or improper description of the defendant in the long cause title or short cause title or in the body of the plaint, that will not make the plaint as a defective one. That is the liberty given to the plaint. Now, sir, what is the view of the Supreme Court on plaint averments? When we are talking about the plaint averments in the light of the provisions of law, the Supreme Court, in a case reported in Shanmugam versus Rajakula Vamsattu Madalaya Paribalana Sangam, reported in 2012, 6 SCC, page 430, the plaint averments should set forth sufficient factual details to the extent that it reduces the ability to put forward a false or exaggerated claim or defense. A plaint has to set forth the sufficient factual details. To what extent? To the extent that it reduced the ability of the defendant to put forward a false or exaggerated claim or defense. So a plaint has to be drafted in a prudent manner, that the averments in the pleadings should not allow the defendant to put forward a false claim or to make exaggerated defense. To that extent, with abandoned caution and applying the basic concept of law of pleadings, the plaint has to be drafted by a prudent lawyer. It will not allow the defendant to take any frivolous defense, any false defense, or to make any exaggerated claims. To that extent, a plaint has to be carefully crafted by a lawyer. And there are number of paragraphs in the plaints: long cause title, short cause title, plaint averments, cause of action paragraph, court fee, suit valuation, court fee paid, and then the relief claimed, verifications, list of documents. A plaint consists of all those important elements. How to read the plaint? The plaint shall be read as a whole. This is what the Supreme Court has said in a decision in Syed Dastagir versus T.R. Gopalakrishna Setti, reported in 1999, 6 SCC, page 337. In that case, the plea raised in the plaint is not an expression of art or science, but an expression through words to place fact and law of one's case for a relief. Together, the true spirit behind it should be read as a whole. It's not plaint is not an expression of an art or science, but an expression through words to place the fact and law of one's case of relief. The true spirit behind it is, it should be read as a whole. As per the law laid down by the Supreme Court, the plaint has to be read as a whole. Then what are the incomplete plaints? I said when the defendant particulars were not sufficient, or if any insufficient particulars are provided in the plaint about the defendant, it is not a defective plaint. Then what are all the incomplete plaints? The courts are not under obligation to entertain pleas if the pleadings in the plaints are incomplete. The pleading should be comprehensive. The pleading should be specific. The pleading should be a complete one. The pleading should be as crystal, as clear. The courts are not under obligation to entertain pleas if the pleadings in the plaint are incomplete. That is the decision of the Supreme Court in Rajasthan State TPT Corporation versus Bajrang Lal, 2014, 4 SCC, page 693. That's all. What are all the, along with the plaints, a lawyer is providing certain facts, certain documents. A lawyer is annexing certain important materials in support of the plaint awareness. In those documents, in those materials, what are all can be treated as the integral parts of the plaint? Title of the suit given on the top of the plaint is not a part of the plaint, as it is not by the verification appended at the foot of the plaint. This is the decision of the Allahabad High Court in Mahabub versus Jivala Pandit, AR 1974, Allahabad, page 413. So, every plaint shall be signed by a plaintiff, and there must be a verification. The facts are verified by the plaintiff, and the top of the plaint, a lawyer is giving a caption or the nomenclature or the name for the suit. This is a suit for bare injunction, suit for partition and separate possession, suit for specific performance of a contract, suit for recovery of money under a pro note, suit for recovery of mean profits. this title given on the top of the plaint is not a part of the plaint, because it is the lawyer inserted on the top of the plaint, and it is not comes under the part of the verification, under the integral part of the verification. Therefore, the title given to a suit on the top of the plaint is not a part of the plaint. Whatever materials verified by the plaintiffs, whatever materials verified and signed by the plaintiff are the integral part of the plaintiffs. And then, sir, as I stated earlier, along with the plaint, sometime to describe the suit property, a plan, a rough sketch may be attached. The plan or rough sketch to describe the suit property attached with the plaint is integral part of the plaint. This is the Supreme Court in AIR 2015-1236, Zarif Ahmed versus Muhammad Farooq, a reported case, AIR 2015 Supreme Court 1236 has held that the plan or rough sketch appended to the plaint is an integral part of the plaint. That is the reason. Thereafter, a pedigree or a genealogical tree is also a part of the plaint. That is the reason, while passing a decree in favor of the plaintiff, most of the courts used to add a word, the rough sketch or plan shall form part of the decree. To describe the suit property or the rough sketch annexed to the plaint shall form part of the decree, because it also treated as an integral part of the plaint. That's the reason why, while drafting the decree, the pedigree, the genealogical tree, or the plan annexed to the plaint are treated as the part of the decree. And what is very important requirement in a money suit is, in a money suit, the plaintiff shall state the precise amount claimed under Order 7, Rule 2. There should not be any vague amount. If at all the suit is based on the foot of a pronote, the plaintiff has to specifically state that this is the principal amount and this is the interest. So the total amount claimed by the plaintiff is that amount to be specifically and precisely stated in the plaint. That is as per Order 7, Rule 2. In Rule 2, if the mean profits is claimed, see, because under Order 20, Rule 12 CPC, the mean profits claimed by the plaintiff may be differ and may sometime vary if the defendants come to a plea, or if the court may come to a conclusion that there could not be such a damages caused to the plaintiff by this and all. Therefore, the mean profits, in a suit for mean profits, the plaintiff shall state approximately the amount or value sued for. If it is a suit for money on the basis of a pronote or negotiable instrument, or if it is suit for a rent, claim arrears of rent, or if it is suit for any claim of money, it should be the relief should be in a precise manner sought by the plaintiff. But if it is a means profits, if it is suit for mean profits, the plaintiff shall state it approximately. That is the exemption given under Order 7, Rule 2 CPC. In a representative suit, the plaintiff shall show not only the plaintiff has an actual existing interest in the subject matter, but he has taken steps necessary to enable him to institute a suit concerning it. In a representative suit filed under Order 1, Rule 10, so far as the civil courts are concerned, representative suits can be called in a lighter vein and a layman language as a public interest litigation. A representative can file a suit on behalf of the others. In such suits, Under Order 7, Rule 4, what is mandatory requirement is that the plaintiff has to show that there is an actual existing interest in the subject matter. And he has also shown that he has taken steps necessary to enable him to institute a suit concerning it. This is the requirement to be fulfilled under Order 7, Rule 4 in a suit filed under Order 1, Rule 8, what is called as a representative suit or a public interest litigation in the district municip or taluk level or subordinate court level. The client shall specifically show the grounds upon which the exemption of limitation is claimed. Every relief has its own limitation. The law of limitation has prescribed a period within which the plaintiff has to come forward to make a claim. In every suit, if there is any exemption is provided to claim the relief without any limitation, that exemption has to be specifically pleaded under Order 7, Rule 6. Normally in a plaint, every lawyer will make this plea as a template that the suit is well within time and it is not barred by any law of limitation. If at all the law has provided or granted any exemption for limitation, that has to be pleaded. The plaintiff shall state specifically the relief claimed or alternative reliefs tried for. Alternative reliefs are important reliefs or important matters to be pleaded. In a suit for specific performance, for example, I am telling it, in a suit for a specific performance, if the plaintiff is not entitled to the relief of specific performance, then he has to plead for the alternative relief of refund of the advance amount paid towards part of the sale consideration. Alternative relief will enable the court to provide that relief if the plaintiff is not entitled to the main relief sought by the plaintiff. This is one of the requirements under Order 7, Rule 7 CPC. See that in a suit, if the subject matter is immobile property, the plaintiff shall contain the description of property to identify it. Normally, the majority of the suits filed before the civil court relating to the immobile property. Therefore, every plaintiff at the penultimate stage of the pleading shall consist of, at the bottom of the entire, after making every plea, the plaintiff has to describe the property with survey numbers and boundaries. They are all the survey numbers and boundaries are the features help the court to identify the property. Therefore, survey numbers, boundaries, extent, and other physical features, if there are any standing trees in the suit property, that has to be pleaded. That has to be described. There must be a separate description of property column in the plaint, and the plaint shall describe the property to easily understand, to easily identify with survey numbers, boundaries, standing trees, if any, and any other special physical features there in the suit property, fence, everything to be described, to be given in the description of property column. That is the requirement under Order 7, Rule 3. Now that, again, this is a matter of lawyer. A client may instruct the lawyer what sought to be done and what the relief he wants, what is his case. But it is for the lawyer who is drafting the plaint to mention the correct provision of law. But there is an exemption given. Ignorance of law is no excuse, but the lawyer can claim excuse under that mere non-mentioning or wrong mentioning of provision of law in the plaint or application is no ground to reject the source. Therefore, if at all by an accidental slip or inadvertently, if the provision of law mentioned by the lawyer in the plaint or any application presented into the court is wrong or incorrect, or sometimes the lawyer may not mention the provision of law, but those defects will not make the plaintiff, will not preclude the plaintiff from claiming any relief. And the courts are also cannot reject the claim on the basis of wrong mentioning or non-mentioning of the provision of law. This is the decision of the Supreme Court in Chalamane Hucha Gowda versus Tirumala. Chalamane Hucha Gowda versus Tirumala, 2004 1 SCC page 453. This decision has gives that ignorance of law. Sometimes lawyers may not know the exact provision of law. In such circumstances, the court cannot reject the claim on the basis of non-mentioning of the provision of law or wrong mentioning of the provision of law. Now that, sir, we are talking about plaint and plaintiff. Hitherto, we are talking about the plaint and plaintiff. What is the relationship with the plaint and defendant? Of course, a plaint is addressed to the defendant also. Defendant is the party to the plaint. There should be two parties to the plaint. But the Supreme Court in P.K. Palanisamy versus N. Arumugam, 2009 9 SCC page 173, has held that the court need not hear the defendant before registering a plaint. A defendant has nothing to say before registering a plaint. A defendant cannot raise his voice even before the register at the time of registering a plaint, or before before service of summon to him. This is the judgment of the Supreme Court in P.K. Palanisamy versus N. Arumugam, 2009 9 SCC page 173. The role of the defendant is absolutely eliminated while registering a plaint. And the defendant's claim and interest in the subject matter to be shown in the plaint. That is very important. The set off, if any, or the defendant's claim, if any, has to be stated. Defendant is claiming with these rights. A defendant's claim is based on these rights. That has to be specifically stated in the plaint under Order 7, Rule 5. Then Order 7, Rule 7 is applicable to the written statement filed by the defendant. See, Order 7 rules, and that is what? Equally, a defendant also has to admit it into the in his written statement. What are all the rights of the plaintiff? So Order 7, Rule 5 and Order 7, Rule 7 has to be read together. A plaintiff has to claim it if any rights claimed by the defendants in the suit, property, or the suit claim, as per Order 7, Rule 5. And Order 7, Rule 5 and Order 7, Rule 7 has to be read together. The plaint and legal representatives, and the legal perspectives of the plaint. A plaint is not a public document. A plaint presented into the court may be considered as a public document. In strict sense, it is not a public document. Merely because a plaint was admitted by a court, it cannot be admitted in the evidence and cannot be marked as an exhibit without proving its contents. Therefore, plaint cannot have the sanctity of a public document. Any plaint admitted or any plaint numbered by the court, a copy may be obtained by a third party or sometime even the party, but it can be admitted in the evidence and it can be tendered in the evidence as an exhibit. But without proving its contents, it cannot be admitted in the evidence. That's the judgment of the Orissa High Court in the year 2014 by Jayanti Nanda versus Jagannath Mahaprabhu case. And A petition filed under the contempt jurisdiction of the High Court is not a plaint within the meaning of Order 7, Rule 7 CPC. A plaint, election petition may be considered as a plaint, but a petition filed under the contempt jurisdiction of the High Court is not a plaint. This is the description in the case in re Siddharth Srivastava that is decided in AIR 2002 Bombay. Bombay High Court has reported in AIR 2002 Bombay, page 494. And after presentation of the plaint, the court, what can do? The plaint is presented by a counsel on record on behalf of his client. So after presentation of the plaint, the duty of the court is the court can admit it under Order 7, Rule 9 or return it under Order 7, Rule 10. Either admit it or return it. If it is admitted, it can admit if it is within the law, if all requirements are fulfilled, the court can admit it under Order 7, Rule 9 and it can be registered and summons may be ordered to the defendant for his appearance. If the plaint, there are certain defects in the plaint, or if there is any vague averments in the plaint, or if the plaint certain ingredients are not fulfilled, then it can be returned under Order 7, Rule 10 CPC. If the plaint is admitted, the copy is to be served to the defendant along with summons. If the plaint is returned, the judge shall endorse the date of its presentation and return the name of the court, name of the party presenting it, and the reason for returning it. Therefore, if at all the plaint is admitted under Order 7, Rule 9, the copies of the plaint can be sent to the defendant along with the summons. If the plaint is returned for the want of territorial jurisdiction or want of pecuniary jurisdiction or for some other reasons, the plaint shall carry the endorsement of the judge who is returning it along with following particulars. What are they? The date of presentation and return, name of the party who presented it, and the reason for returning it. What will be the consequences after the return? After the return, the plaintiff has to take back the plaint and represent it before the court which has got jurisdiction and competent to try this plaint. After presentation before the court of competent, after representation before the court of competent jurisdiction, the plaint is to be considered as a fresh plaint and the trial is to be conducted de novo, even if it stood concluded before the court having no competence to try the same. This is one aspect. De novo trial has to be ordered. But if it is a money suit, the suit interest cannot be claimed from the date of the suit was presented initially in the court which lacking jurisdiction to try the suit. The suit was mistakenly, the money suit was presented mistakenly before a court which has no jurisdiction. In such a case, the interest can be claimed by the plaintiff only from the date where it has been taken into consideration or taken on account or where it was admitted by the court which has the competency and jurisdiction to try the suit. These are the guidelines of the Supreme Court in the decision in ONGC Limited, ONGC case, and reported in 2014, AIR 2014 Supreme Court, page 83. And there, sir, almost we are at the last stage of this webinar lecture. Amendment of the averments in the plaint. after cognizance is taken on by the court, the plaint averments cannot be altered or changed or amended except by the permission of the court under Order 6, Rule 17 CPC. The amendment of pleading is an yet another area of the civil jurisprudence. There are a lot of post-trial amendment, pre-trial amendment, lot of challenging and lot of debatable points are there that has to be dealt with under Order 6, Rule 17. A plaint taken into cognizance cannot be altered and its averment cannot be touched by the plaintiff except by the permission of the court under Order 6, Rule 17 CPC. With that, sir, I would like to conclude that the plaint is an extremely important document, reflect the lawyer's legal acumen, drafting ability. It is the frame of a case by a lawyer. It is drafted in the chambers of the lawyer, but considered by the chambers of the judge to grant a relief. With that, I conclude my discussion on the plaint, its particulars and procedures. I am once again thanking Mr. Vikas for granting me this opportunity to interact with the legal fraternity. Thank you so much, sir.
Thank you, Mr. Satyamurthy. The way you elucidated every aspect itself shows that the way you could hammer the point while expressing the things, and the platform is all gaga about the manner in which you have expressed the things. And they have also expressed that if you could just share these notes, once they are shared, the PPT, I can share it on the WhatsApp group of Beyond Law CLC. Is it audible?
Yes, sir, audible.
Yeah. So it is, under which conditions or circumstances a plaint can be rejected by a bench? Can a plaint be amended second time in case additional evidence and facts do come forth? And is it illegal to charge a plaintiff with fine in case of amending the plaint is at the stage of arguments?
It's a question, huh?
Yeah.
Sir, amendment of plaint, the question consists of two important aspects. One is under what circumstances the plaint can be rejected. Rejection of plaint is dealt under Order 7, Rule 11 CPC. Amendment of plaint is dealing under Order 6, Rule 17 CPC. Both are very big areas. Today we have discussed on the particulars and the procedures governing the plaint. So rejection of plaint, my friend can read Order 7, Rule 11 CPC, and whether it can be amended second time or third time. A plaint can be amended second time or third time, or multiple amendment is possible, can be looked into Order 6, Rule 17 CPC, sir.
No. So this is by Sachinandan Pai. The earlier question was by Abhishek Sharma. This is by Sachinandan Pai. What is the time limit to raise a counterclaim and set off?
What is the time limit to counterclaim and set off, sir? Set off, you can make it only in money suit. Counterclaim can, it is Order 8, Rule 6 and 6As are there. Under Order 8 and Rule 6A, at the first hearing of the suit, immediately on receipt of the summon from the court of law, the defendant has to appear before the court and he has to make the counterclaim or set off, whichever is applicable, on the date of presentation of the written statement. It depends upon the date on which the cause of action arose for the counterclaim and the set off. Therefore, at the earliest point of time, because we can't give a straitjacket formula or universal formula, all the counterclaims has to be made within 3 years or all the set off can be made within 1 year and all. Immediately after receipt of the summon from the court of law, on the date of filing the written statement, the written statement shall consist of the counterclaim or set off under Order 8, Rule 6 or 6A. There can't be a straitjacket formula. It depends upon the relief claimed. It depends upon the claim involved in the suit.
This is if a plaint is amended by a defendant and a copy is received. I suppose he's written wrongly because it says if a plaint is amended by it should be plaintiff.
Plaintiff is the
Yes.
dominus litis of the plaint, and it
Yes.
can't be amended by the defendant.
That's what I'm saying.
Yes.
I think he has written wrongly. It should have been and a copy received by a defendant without permission of the court. Can the defendant raise an objection on the amendment?
Please repeat the question, sir.
He says a plaint is amended by the defendant and a copy has been received by the defendant
Hmm.
without permission of the court. Can defendant raise an objection on the amendment of the plaint?
Without permission of the without permission of the court and without the knowledge of the defendant, plaint cannot be amended at all. How can a plaintiff can amend the plaint which has been presented into the court? The moment it has been presented into the court, it has become the document of the court, and the plaintiff has no right to amend it at his whims and fancies. If at all he wants to amend the plaint, though he is a dominus litis, if at all the plaintiff wants to amend the plaint, he has to present an application under Order 6, Rule 17 CPC, in which the defendant has to be served with a copy of the notice, and the defendant has to either object it or he has to concede with the amendment. Therefore, without the notice and without the knowledge of the defendant, plaintiff cannot unilaterally amend the plaint. That is one aspect. And what is the second aspect, sir? He is asking.
He says, can the defendant raise an objection on the amendment?
Yes,
that is just like Order 6, Rule 17. Once the notice is sent, then you
yes,
have to
he can
reply.
raise the amendment, because the moment it is the plaintiff defendant is at liberty to raise his objection. He can raise the objection before the amendment.
He has to fulfill those 3 criteria laid down on the
Yes,
Order
sir,
6,
yes, sir.
17. Is it legal to charge a plaintiff with fine in case of amending the plaint at the stage of arguments?
Sir, the question of fine.
It will not be fine. I suppose he wants to say cost.
Civil suit, it is only a cost.
That's what
Cost. See, sometime the amendment might have been done at the earliest point. Even the defendant might have died at the inception of the suit, but the plaintiff will slept over and come at the penultimate stage of the trial and ask for amendment of the plaint that the fourth defendant is died and his legal has to be impleaded. In such cases, nominal cost has to be impleaded. Nominal cost has to be imposed upon the plaintiff. It is the discretion of the court. Where is the question of fine or illegal or something?
And cost is basically also to compensate for the time the court has spent or the party has lost.
Yes, sir.
In that
has to
flux
be
of time.
disposed of expeditiously. Hello? I'm not audible, sir, please. I'm not audible, sir, Mr. Vikas.
To file a rejoinder when there is no such stage. पोस्ट का दोबारा लॉग इन करें Centur. Centur, you will have to unmute Satyamurthy because you have been the host. Mr. Murugan, kindly allow me to make the host or unmute Mr. Satyamurthy. Host हो सकता है कि नहीं? Yeah, beyond law हो गया, कर ले, unmute कर. Thank you. We are unmuting Mr. Satyamurthy. You will have to unmute yourself.
Yes, sir. Now, am I audible now?
Kindly do that again.
Am I audible now?
Yes, yes.
Yes, sir. Please, sir. Your question, please, sir.
Yes, it's audible.
Okay, sir. I am audible now. If any questions, sir.
Yes, question is.
Sir, I couldn't hear your voice, please. Some technical snag.
Yeah. So the question is, I'm sorry for the technical snag. It
Yes.
says that rejoinder is not as a matter of right, but still the courts allow the rejoinder. What is your take on that?
Rejoinder, you
Is
see.
it audible?
Yes, sir. Am I audible now? Am I audible, Mr. Vikas?
Yes.
This rejoinder is not a matter of right, and you can't say
Yes,
that
yes, it's audible.
in a trial, the plaintiff is entitled to file a rejoinder. If the defendant raised any new plea in his written statement, it is for the plaintiff to make a rival submission on his part. It is just giving a party to comprehensively liberty to raise comprehensively his pleas, his case, his ideas, his thoughts. So it's not disallowing a plaintiff may not be a fair during a fair trial. Therefore, normally the courts are very liberal in allowing the plaintiff to make a rejoinder. It's a matter of discretion, but allowing the plaintiff to make the rejoinder will allow the plaintiff to put forth his case in a comprehensive manner. Therefore, the courts are allowing. Nothing wrong in it.
It says, this is by Amar Kumar Sahu. Head
Yes.
note of the suit is not disclosing the provisions, section, and rules under which provision the relief has been claimed on, but the body is disclosing everything. Whether the plaint can be rejected in such a case?
See, I have stated at the inception of this lecture, a plaint has to be read as whole. A plaint averments has to be read as whole, and therefore every court, civil court under section 151 CPC has the inherent power to mold the relief to meet the ends of justice. Therefore, though there is no mention of correct provision of law, or even there is a wrong provision is quoted, the claim cannot be rejected and the relief can be molded by reading the plaint averments as a whole, and the relief can be granted to deserving parties before a court of law.
Can the plaint be amended during the first or second appeal?
Plaint can be amended during the first.
Mr. Satyamurthy, can the plaint
Be amended during the
Yes.
first appeal or second appeal? Huh?
Yes.
Yes, sir, it can be amended. There are if there is a mitigating circumstances, I would tell you that a suit was instituted. I will give you a hypothesis case to my friend. A plaint is filed against 5 defendants. 4th defendant died, leaving behind his daughters. Now, during the trial court has allotted suit properties to these preliminary degree was passed, against which first appeal or second appeal was preferred. So, in such cases, the mitigating circumstances will make the plaintiff to amend the plaint, because decree has to be amended consequently. Therefore, the plaint can be amended during the first appeal or second appeal, but it is not that introduce a new cause of action. It shall not introduce a new subject matter. There are a lot of things. Only mitigating circumstances can permit the plaintiff to seek the permission of the court for the amendment of the plaintiff.
This is, in fact, 2 persons somehow had been logged out. I would request Mr. Venkat Srinath and Radhesham Maurya to repost the questions. So this is, yes.
What's the question, sir?
Venkat Srinath. In a suit,
Yes.
in a suit asking to declare a registered deed as null and void, the plaintiff is his own sister of defendant but residing in law's place. Should plaintiff ask for a consequential relief, or is it enough to ask for a bare declaration? To avoid huge court fees, property is more than rupees 100 lakhs, and to avoid court fees, plaintiff had asked only to declare the deed as null and void. If plaintiff is a relative, should plaintiff also claim a consequential relief without failure, or what?
Suit property value is more than 100 lakhs. To avoid court fees, plaintiff has asked only to declare the deed as null and void. The plaintiff is a relative, should also see. It is for a good lawyer to make a plea at the earliest point of time that the suit property is undervalued and the suit property has not been properly valued for the purpose of court fee and jurisdiction. He has to raise such a plea before the court of law. And the court fees is a matter to the exchequer, a revenue to the exchequer of the state. So court will be always double cautious while dealing with court fee. It is for the defendant's lawyer to raise a plea, and if the court fee is not properly paid, if the court property has not been properly valued and proper court fee is not paid, it is for the defendant lawyers to make a plea, and it is up to him to raise such a plea before the earliest point of time at the trial court. Next question, sir.
The last question we will be taking of Raj.
Yes.
The last question we are taking with regard to your experience regarding pleadings, seen in your experience. Are most pleadings unnecessarily long and unwinding? He says, are the pleadings very long? What is your take on that? Is it audible?
Sir, last question. Audible, sir, not audible.
Yes, sir. It says, what is your experience regarding pleadings? Are they quite long? What is your take on that?
See, it's all depends upon the lawyer who is drafting. There, if you go through the digest, our Supreme Court has said that there are Mofficial plaint and metropolitan plaints. It has said Mofficial plaint means a lawyer with a limited years of experience and with a limited infrastructure may drafted the plaint with the available resources, with available infrastructure with him. Those plaints has to be liberally interpreted. It is not that the for a court or a judge, it is not that the who has drafted the plaint and how it has been ornamentally worded. The litigant is deserving for the relief or not. We are only rendering justice, addressing justice to the litigant, whether it is a plaintiff or defendant. Who is entitled, who is deserving, that is the matter to be determined by the court of law. My experience and all, there are good plaints, there are plaints there are good plaints, there are equally sometimes the quality of drafting may not be up to the mark, merely because the quality is not there or quality is not up to the mark. We cannot reject the plaint or we cannot throw out the plaint to the legal waste paper basket. At the end, we have to render justice to the deserving litigant. That is the aim of the court and that is the motto of a good judge. Mr. Vikas ji?
Yes. I'm just taking one of the, since you had written about Justice Krishna Iyer had said one line, I was just looking upon that on the net. That we quite
Yes.
often use from Justice Krishna Iyer's judgment on procedural law. It says that we must always remember that the procedural law is not to be tyrant, but a servant, not an obstruction, but an aid to the procedure. Handmaid of justice. It is quite oftenly used because I just remembered that you had written an article on Justice Krishna Iyer. So I thought that before we conclude on that, so that's the best apt way. One of the finest judges who has written the judgments in the finest language. One can only read his judgments with an awe and understand the law when you read the judgments of Justice Krishna Iyer. So we will not be taking any other questions. And thank you, friends, those who have stayed connected. Yes, at the end, there were certain glitches. But as they say that one has to keep on trying. And by the end of the day, it was a show where Mr. Satyamurthy ji has given the insights in a different perspectives, and they were quite elucidatedly explained. And I will just read one of the messages written by him, by Mr. Abhishek Sharma. He says that was an extraordinary session and excellently explained. Thank you, Your Lordship, L.S. Krishnamurthy. And they are only requesting for the notes. I will request you that kindly share the notes. Is it audible?
Yes, sir, audible. I will share
Is it
with
audible?
you. I will share with you and you can share with the delegates.
Thank you. Yes. Yes, yes. And tomorrow we have a session at 5:30 p.m. It is India's federal structure and doctrine of repugnancies, Constitution of India. Those who have read Article 254, they will understand. And even otherwise, Surit Parthasarathy is a renowned lawyer down south, and he writes quite often on different platforms and social media, especially the Hindu. So do stay connected with us. Mr. Surit Parthasarathy's father also had given a talk which was very well received. And we are quite sacrosanct that Mr. L. Satyamurthy will be giving insights on different perspectives of law, because the way we have heard him and otherwise also we have seen him on the YouTubes, his insights on different perspective of laws have been quite amazing. And thank you everyone. Stay safe, stay blessed. And after a sumptuous food for thought for the mind, you can have dinner for the stomach itself. Stay safe, stay blessed, and thank you everyone. And thank you, Mr. Satyamurthy ji, and to all those friends who are watching us live on the Facebook and on this platform, and subsequently who will watch us on the YouTube. Stay safe, stay blessed. Thank you so much.
Thank you. Thank you so much.